No part of this lecture material may be used without the written permission of Rick Ramos or Contra Costa College. Hello, this is Professor Rick Ramos, and this is the sixth lecture in the Criminal Procedures course, and it's entitled The Adversarial System. First, we're going to be talking about the district attorney. So, officers typically make an arrest on the street. They write a report, they process the person, it goes to the district attorney, and they decide whether or not they're going to prosecute the case. Each county has a prosecuting attorney, which is usually known as a DA, or district attorney, or county prosecutor, who usually is elected by the general public every 4 years. He or she is the only person with the legal authority to charge someone with a crime in that area. His or her role is not just to prosecute criminal cases, but to also make sure that justice is done. Therefore, they're obliged not to charge a person unless the evidence is sufficient to warrant a trial. This is a huge responsibility, and that's why they're elected, and the public determines whether or not they've done a good job. Now, the district attorney doesn't personally deal with every case. They have deputies that handle most of the cases for them. They're staffed by a number of deputies or deputy county attorneys, depending on the size of the office and the prosecutorial workload. Under the traditional prosecution model, each attorney is assigned to a specific duty within a department. For example, one might be assigned to a lower court to represent the state during all initial appearances by accused persons. Another might conduct all preliminary examinations, and another might prosecute offenders in misdemeanor trials or handle all traffic matters, while the really experienced ones, the ones that really know their stuff, deal with felony court trials. So it just depends on how much experience you have as to how you're going to be assigned. It usually starts with a deputy being assigned to a complaint desk where they're reading the police reports and reviewing them with officers who are the liaison officer from the police departments. Those officers will answer critical questions about the investigation, and then the district attorney will determine whether or not there's legal cause to charge the suspect in the case. They may also have some questions about search and seizure and whether or not there were any violations of evidentiary law. Next, the DA decides on what to charge. Do they charge a felony or a misdemeanor, multiple counts, lower level, higher level felonies? They have a lot of responsibility, and they have to make sure that they make a great call. Now, a lot of times they'll do what we call loading, or they'll load a lot of charges or a number of charges on to a suspect in order to hopefully get a plea bargain at a later time. Many crimes are punishable as either a felony or misdemeanor at the discretion of the DA. These are called wobblers. An example of a wobbler would be 261.5 PC, which is statutory rape. In statutory rape, the punishment can be either 6 months, 18 months, or 24 months. So 6 months, that would make it a misdemeanor. 18 months would make it a felony. 24 months would make it a felony. The DA will determine whether or not how they're going to charge it, if they're going to charge it as a misdemeanor or they're going to charge it as a felony. The district attorney wears a number of different hats. They have different roles. First role is a trial counsel for the police. They reflect the law enforcement view in court, and they take a crime finder stance in the public. Next is their house counsel for the police. They give legal advice so that arrests will hold up in court. The next hat they wear is they're the representative of the court. So they want to make sure the police are out there enforcing the law, but they want to make sure that the police are following the rules. So they're enforcing the rules of due process. They make sure that the police act in accordance with the law, and they uphold the rights of the defendant. And the last hat they wear is, you got to remember, the DA is an elected official. So they have to be responsive to community opinion and think about the political ramifications if they charge a case or don't charge a case. There's some examples in the book where they talk about, there's some cases that went on where a young man is charged with sexual assault on a child, and it's an 18-year-old who has a sexual relation with a 15-year-old in the community. It's consensual. She becomes pregnant. They're intending to marry and raise the child, but the DA prosecutes him. Now he's got to register as a sex offender. And so the public wasn't really happy with that. That was in Port Washington, Wisconsin. There's another example with the DA in Sonoma County in a case where there's a home intrusion. Somebody breaks into a person's house, and this is after the Polyclass case. It's a famous case that occurred in California where a young girl was kidnapped and later on found sexually violated and also killed. She was murdered. But a man hears somebody breaking into his downstairs room. He grabs a baseball bat, goes downstairs where he finds a burglar climbing in the kitchen window. He struck the man in the head with the bat, and the guy tries to escape. He chases him and strikes him 3 more times. In the meantime, the police show up. When they show up, they see this guy wielding the bat over a limp body of the alleged burglar, and the burglar's unconscious, taken to the hospital. He's almost out for 40 hours, and the police arrest the homeowner for hitting the burglar on a charge of assault with a deadly weapon because he had become the aggressor when the man was trying to escape. So the public was really, really upset with this because they felt that the homeowner should be able to defend their home. Okay, so key players that the prosecutor depends on because they can't do it by themselves. You have the police who are preparing the case and collecting the evidence and bringing the defendant forward. They're making the arrest. You have victims and witnesses who, through testimony, help the prosecutor to do their job. And then you have to know the judges. You got to know the past history of judges' decisions and have a good relationship with the judge. And it helps you to decide on what cases you're going to plead out or not. Because if you know that a judge typically is going to give a defendant probation, why would you go through the whole case? On those sites, if it's a lower end misdemeanor. So the traditional prosecutorial model, let's talk about, there's 2 models that are used. One is called vertical and one is called traditional. Traditional is that the report comes to a complaint desk, and there is usually a rookie DA, deputy district attorney, that's going to decide what to charge, whether it's a wobbler or not, and the level of seriousness. Decision-making policies, there's a variety. This is not in the book. This is kind of stuff that I found over the years of doing research in this area. There's usually 3 different models that are looked at. One is the legal sufficiency model. This is the district attorney who just looks at the minimal legal requirements to proceed to a preliminary hearing. So if there is corpus delicti for the crime and it looks like there's probable cause for arrest, they're going to go for it. Then there is the systems efficiency model. In that model, there's 3 factors that are reviewed. First, the caseload of the district attorney. And then next, can they get a quick, easy disposition? Is it early? Is something they could plead out on? Is the evidence adequate, or is there going to be too much time to handle it? Is it going to be costly, etc., etc.? Was it collected legally, etc.? Can a plea bargain be struck to save time and money? And in the system efficiency model, because you have so many cases going on, you try not to go to trial if possible. Next is the trial sufficiency model. This is the district attorney's office that's really concerned about a win-loss record. They're more concerned about, can we win this case? And if we can, we'll go ahead and go forward. Now, when in the traditional model, when the district attorney or the deputy district attorney is reviewing the police report, they're looking at some of the following things. Sufficiency of evidence. Was it collected? Is it relevant to the case? Was it collected legally? The legality of officers' conduct. Was the original stop legal? The seriousness of the offense. The wishes of the victim. Are they going to prosecute, or are they going to be someone who does not want to get involved in the case? Are they going to be hard to get cooperation from? The risk posed to public safety. Does this particular individual need to be prosecuted for the good of the public? What is the community sentiment regarding the offense? Is the community pro or con on this? Is this something that's going to affect the district attorney later on when he goes for election, looking like he's too hard or he's too soft on crime? The potential punishment and whether it is mandatory. And that means if there's a mandatory sentence for a certain crime, then the defendant is less likely to plead guilty on a case like that. They're going to go to court because they know they're going to get 25 to life or something like that. Also, the offender's role in the crime, their prior record, the willingness of the accused in helping investigators in other investigations. All those things are going to be looked at to determine whether they're going to prosecute that particular defendant. Also, the motivation of the complainant. Why is a person making these accusations? Is it a divorce case and now the wife wants to say that she's a victim of domestic violence to try to help her divorce case out? Also, the impact of the trial on the victim, especially if they're young. If going to court on this case, if they can work out a plea bargain and spare a young child who maybe was sexually molested of having to revisit that whole situation, they might do that. They might take the plea bargain instead. Now, there's a mixture of politics and prosecution, right? Because if you're an elected official, then you're going to be influenced by public perception and your need to get reelected. High profile cases are going to be given high priority, and campaign contributors are going to be looked at in a case by case basis. I can't say they're not going to get special treatment, unless they become really high profile, then of course they probably won't. But in cases where someone gave the district attorney a large amount of money, the district attorney has the option to do what's called nolle prosequi, and no one can really do anything about it except not elect them next time. In the early 1980s, the Career Criminal Apprehension Program came around, and as a result of that, you had what was called vertical prosecution versus traditional prosecution. This was to deal with the specific career criminal element that was out there and to try to lower the overall crime rate. Now, again, the traditional model is that a certain deputy DA handles certain tasks, charging, prelim, arraignment, and trial. But in the vertical model, the district attorneys that are working in this area are given the latitude to handle a few number of cases, but they may handle 100 career criminals that they basically have in their file. And when those career criminals go to trial, so basically this would happen. John Jones gets arrested. He goes into court. In the traditional model, he meets DA Smith, who offers him a deal, and he turns it down because he thinks he'll get a better deal in Superior Court. Then he meets, DA Thompson in Superior Court, and DA Thompson gives him a better deal, so he takes that deal. In the vertical model, DA Rowland is the person who's dealing with the vertical model. Okay, he's doing career criminal prosecution. So he shows up at court because John Jones is there and he's on his list. He shows up at the original first initial appearance. He meets with him and he tells him, I'm representing the county, and here's what's going to go on. We're going to go to trial on this unless you deal out at this higher level of time. And of course, John Jones is going to say no. Well, when they go to Superior Court, John Jones figures he'll get an easier DA, but when he walks in the room, guess who's sitting there? DA Rowland. He's sitting there again, and he's handling the case. So what happens is when you have one particular district attorney take the interest in dealing with a certain number of career criminals, those career criminals get more time and they're off the street and the crime rate goes down. Again, the deputy district attorney works under the district attorney, and their primary role is to represent the prosecution at each stage of the legal process. How do they do that? Well, when the officers are out starting to do the investigation and making arrests, the district attorney is assisting them with a search and arrest warrant composition. They're screening cases and counseling the police on what additional steps need to be done. Who do they need to interview? What evidence do they need to go back and collect? In the initial appearance, they represent the people and they inform the court of the accused of formal charges that they'd like to proceed with. They also try to set bail or argue with the defense about what sort of bail will be set up. They can also do nolle prosequi and basically dismiss the case. Nolle prosequi means to decline to prosecute. When the defendant goes to preliminary hearing, they try to establish probable cause to hold him for trial. And at that point, they might also nolle prosequi if they see a problem with the case. They can oppose bail reduction, and in the 1538 hearing, which is the evidentiary hearing, they're going to try to establish that officers followed correct procedure and best practices in collecting the evidence legally. They'll also be meeting with the defense during this whole time to try to work out a plea bargain if it's possible. During arraignment, they present the charges against the accused in the form of an indictment or an information, and they acknowledge the defendant's plea. After the charges are read, the defendant will get a chance to enter a plea. And they will then again conduct plea bargaining sessions that they'll try to deal with there. They're going to also be involved in the pretrial process, where they're going to prepare the case for trial by reviewing the evidence, interviewing witnesses, oppose pretrial motions filed by the defense, and accept plea bargains if possible. When they go to trial, again, during this whole time period, they're going to be dealing with plea bargaining. They're going to take an adversarial stance in jury selection. They're going to try to prove the state's case beyond a reasonable doubt. In sentencing, if the person's found guilty, they're going to try to recommend and justify the sentence that is issued. And during appeal, they're going to try to argue to counter the appeal filed by the defense. Now, many DAs have to deal with community sentiment. I've already given you a couple examples you can look at in the book. Should the district attorney take into account the community opinions about whether a case should be charged or not? This would be something that we will probably talk about in discussions in the discussion area for this online course. Terminology that you need to be aware of as it relates to this chapter. The first term is necessarily included offense. This is an offense committed for the purpose of committing another offense. In other words, if you do an armed robbery, the original offense is 211, but you're also in possession of a loaded firearm, so you could be charged with possession of a loaded firearm in public and also possession of a concealed weapon. You might also be charged with assault with a deadly weapon if the firearm is pointed at the victim, and also brandishing a weapon. So you could see where you could stack up these charges. The next term is count, C-O-U-N-T. This is each offense charged the indictment or information. In other words, if someone is charged with a robbery and assault with a deadly weapon, it would say one count, or count number one would be PC 211 armed robbery. Count number two, PC 12031 possession of a loaded firearm, and so on and so forth. It must be listed on the information. Discovery. Discovery means that the prosecution, pretrial disclosure to the defense of the facts and evidence they'll use in trial. There's also cross-discovery, which means that the defense must tell the prosecution exactly what it is that they have. Nolle prosequi, we've already talked about that term, and that means charges will be dropped or dismissed. Concurrent sentencing. This means that the terms of incarceration run together. In other words, if you have someone who's sentenced to 1 year, 3 years, and 5 years, they're actually, if it's concurrent sentencing, they're actually only going to do 5 years because all of the terms start on the same day. In consecutive sentencing, each term of incarceration is served separately, meaning that 1, 3, and 5 years, you'd add them up, 5, 8, 9 years. So that's a big hammer that you can swing when you're trying to do plea bargaining. You could say that you'll give them concurrent sentencing versus consecutive. The next term is plea bargain, and that's where the prosecutor works out an arrangement to give consideration if the defendant pleads guilty. Next term, accusatory process. The events that take place from arrest and booking through the filing of formal charges of the defendant in court. Next term, diversion. This is an alternative to prosecution and usually found under PC 1000. Usually diversion occurs when someone's arrested for personal possession of drugs, even if it's heroin or PCP or methamphetamines or cocaine. It doesn't matter. As long as it's only for personal use, it would be allowable under PC 1000. The person can go through a drug diversion program one time in their lifetime. That is the end of Lecture 6, Part 1 in the Adversarial System. We will pick up starting with the defense attorney in Lecture 6, Part 2.